We've made it. This is the very last session. Thank you for hanging in there. Thanks again to our sponsors and affiliate firms, and to the people on our planning committee, to Julianne and Shilpa and to Alex, and a special thank you to Tom Kim. Tom, you've been a great chair of this session. You've led us through a plague. You've led us through, all of the things that could happen to ruin this conference. You just led us fearlessly through, and we've emerged on the other side with one of the highest attendance sessions that we've ever had, and it's been fun, and we had fireworks. So thank you again. Can you join me in thanking Tom? So this is our last session. If you were there last night, and if you were able to hear the loudspeakers, you heard who our new vice chair is. I'm going to be taking over the mantle for the chair spot for this conference for the next couple of years. And much to my delight, the gentleman back here to my left, hiding back here, thank you. Dave Lynn is going to be the vice chair. We are really lucky to have Dave. We're really lucky. As you know, if you're a regular at this conference, he and our late friend Marty Dunn added a lighthearted look at all of these topics throughout. He's a master of these concepts. He's been a thoughtful contributor and added a lot to our planning committee through the years. He also does pretty much everything in the federal securities world, as far as I can tell. In addition to his work at Morrison Foerster, he's co-editor of the corporatecouncil.net, the Corporate Council, compensationstandards.com, the Corporate Executives. There are just so many things that he does. Now that you are watching his name, you'll see him everywhere, which is great for us. And it's wonderful, and I think we're going to have a lot of fun. So I'm going to turn it over to him to introduce Lona. Thanks, Dave.
Great, thank you, Dixie, and I'm really thrilled to come into the role and have the opportunity to work with you as the vice chair of the Institute, and I'm very much looking forward to working with folks at Northwestern and with the planning committee on moving us forward into the next 50 years of these conferences and being able to contribute to that. But it really is my honor today to introduce the moderator for our next and final panel, which also happens to be my favorite panel, and that is everything you always wanted to know about securities law, but were never given the chance to ask, which is one of the longest panel names I've ever encountered in my years of paneling. And I feel like every time we do this panel, we do honor the legacy of my dear friend and colleague, Marty Dunn, who always made this panel a highlight of the Institute and taught us a few things along the way. So unfortunately, Dennis Garris, who was slated as moderator for this, was unable to join us today, but we're very fortunate that Lona Nalangara will serve as our session chair for today's program. Lona's a partner at Sherman & Sterling, where he serves as a global head of corporate business unit, and he's a capital markets lawyer there as well. And Lona served in important positions at the SEC. That included chief of staff to the chair, as well as deputy director of the Division of Corporation Finance. Lona, take it away.
Great. Thanks, Dave. Thanks for everyone for staying, pushing through to the end. When I worked at the SEC, we'd have, this was back when we had open meetings and people would come in. I would stand, and this is for rulemakings, I would stand at the back row where all of those people are, and one of the commissioners asked, "Why do you stand back there?" And I said I was always worried that someone was going to rush the stage, and if they did, I wanted a quick exit. So I don't think anyone's going to rush the stage for what we say. So for the people in the back, there's lots of space up front. It would be great if you wanted to come and join us a little closer. So this is the favorite session of the Institute. That's why it's the end, and we have a great set of panelists to join us. Today, Dennis unfortunately couldn't be here, but you will see his contribution in the questions and the answers that we have today. But let me introduce our panelists and going down the road here. Scott Siamis is the Senior Vice President and Associate General Counsel at Salesforce. Raquel Fox is a partner at Skadden Arps in the Washington D.C. office. I had the pleasure of working with Raquel at the SEC as well. And Justin Ho is a partner at Oric and in the San Francisco office. So we have a bunch of questions and hopefully answers to those questions. Some of these questions were questions that you stuffed in the box that was in the front there. We may have modified the form of the question a little bit to protect the innocent and also to maybe protect the institute. Some of the questions were a little passionate, so we may have moderated them a little bit. So what we're going to do is we're going to just each of us is going to take a question and take an answer, and then maybe we'll disagree with each other, and hopefully we'll all learn a little bit more as we go through these. So let me start with our first question, and I think JT, this is yours.
Oh yeah, so he's called me Justin and JT. Yeah, it's fine. I go by JT Ho. That is my professionally, but at some point I was born Justin Ho, but that's all good. So I'm going to promise that this is going to be my longest answer to the whole panel, but it is a really robust question and a good one, which is, in light of the proposed SEC climate disclosure rules and recent comment letters issued by the Division of Corporation Finance to a number of companies related to existing climate disclosures, should a company be reconsidering its Form 10-K disclosures to include or supplement with information related to climate strategy, policies, risks, and opportunities included on its website or its corporate sustainability report or ESG reports? And so I'm going to actually give a broader answer. You shouldn't just reconsider your 10K. You should basically reconsider how you're doing all your ESG disclosures or CSR disclosures. And I think this question is being driven by the recent comment letters that we've had in the last few years regarding climate, where it's clear that the SEC is looking beyond just the 10K disclosure at other voluntary disclosures like CSR reports, ESG disclosures on websites. There's also a recent case, the Bali case, involving a mining company, where they looked at things like the ESG webinar, as well as the disclosure report in a serious enforcement action. So I think you should reconsider all these things, and how should you do them? Traditionally, in the old days, and I think Scott can attest to this as well, but companies really operated in different silos when it came to ESG or CSR. These things were created by different groups. There wasn't a lot of cross-functional work. You had disclosures in which certain statements were made and certain words were used, like material or significant. Many companies this day even have things that are called ESG materiality assessments. Those are very loaded words in SEC terms. And what I think you need to strongly consider doing is creating all these disclosures in a consistent way. You need to look at them all at the same time. And a lot of the work I did last year was helping companies sync these disclosures together and figure out what is actually material in terms of SEC terms. To the extent things that are not material appear in these reports, including careful language saying, the extent we're calling this a materiality assessment, we're not using it in the same way that the SEC means. Or in the case of some of those reports, that we call them significance reports. Certain nomenclature you can't really avoid because of the way the TCFD does things, but again, really important. But when you actually put in your 10K, there is a rule set out there that guides us. Even though there are proposed rules that aren't adopted, you still have the 2010 guidance, you still have the climate change letters, and you do have these enforcement cases. But one of the things I would do also is really rethink what some of these ESG things that you're doing are in the context of other these disclosures. What I mean by this, for example, is you do a TCFD report. Well, what about having that TCFD report being reviewed by enterprise risk management to see if any of those risks that are identified rise to the level of ESG materiality? Another thing you could potentially do, to the extent that you're actually considering ESG as an important aspect of your company's business strategy, making sure that's appropriately reflected in your risk factors. And the extent that you're spending money on ESG products, assessing whether or not those are actually material from a financial perspective. To the extent they aren't, making clear in the caveats and various disclosures you make to the CDP or to, for example, submissions to the Dow Jones Sustainability Index, that those are not, in fact, they are indeed risks, they are indeed material expenditures in some sense, but not in the sense the SEC is talking about. So those are all the sorts of things you ought to really be thinking about and doing. But the long and the short of it is, the bottom line lesson I would encourage all the corporate issuers here is to really think in terms of all these disclosures the same way. They're not really all that different in many regards, at least in terms of the SEC lens. And I would strongly recommend doing a cross-functional approach. If you're going to do a subcommittee, for example, of your disclosure committee to look at these things, make sure that there's the same person that's on your disclosure committee that looks at your SEC disclosures, so you have that sort of continuity in terms of personnel. Happy to talk more about that, but again, I promise this is the longest answer I'm going to give to a question.
Can I ask,
Yeah, sure.
These things are often on different timetables, right? Your
Correct.
10K, people are going to file it in the next week or so, but the sustainability report, CSR report, could be months away. What's your advice on how to manage those two different sequencing?
Well, there's a few clients here right now in the audience who can tell you what my approach is, which is calendaring is really important. And trying to figure out when you're going to file the 10K, when you're going to file the proxy statement, when you're going to submit your CDP report, when you're going to do your ESG or CSR report. Integrated reporting is really hard. I do think that it's a good thing if you can try to master it. But once you kind of see the order of when these things are due, start creating the different work streams, put together that timeline, and get the right people involved. Figure out who from the company is going to be looking at these different things. You'd be surprised in this process who gets engaged. It's not just the lawyers. There's people that work, for example, in facilities, et cetera. You have to just make sure you're all in the same time frame, and having working groups is really important. And the last thing I'll say is, if you look at the proposed rules, there's a big focus on management oversight of ESG, not board oversight. That is also covered. Part of effective board management is to make sure that you are looking at all these different groups, coordinating these different work streams, calendaring, making sure the appropriate people are in there, and essentially creating the controls that you need to ensure that your disclosures are consistent, accurate, and not misleading.
Yep. So the answer of the ESG report happens later. We're not worrying about it now. Is just not going to. It doesn't seem. It shouldn't have worked before the rule proposal, but it certainly won't be once that rule comes into play. Let's go to the next.
All that said, and I love everything you said, and I totally agree with it. But to actually answer that question, no, we're not making any sharp turns because of the proposed rule. You know, like
that is great.
Like not right now. We're waiting until the final rule comes out to really see what's in there. But we've been doing this a long time.
Exactly, and that's what I say. Look at the 2010 guidance. Look at the comment letters. The comment letters aren't based on the proposed guidance.
Yeah,
they're really
right.
building off of that. So totally agree with both of you on that point.
So the next question is for Raquel. I'm surprised. I mean, last year I think there was like 3 days on SPACs. This year we have barely 3 questions. I'm not sure what that's saying, but Raquel, can you take those?
Sure. So what is the status of the SPAC rules? Are they still coming? What is the purpose of the fairness opinion in the de-SPAC process? So the SPAC rules are very much still coming. They're still on the SEC's agenda. That agenda is, of course, aspirational, but they are slated to be issued by April of this year. But in overarching, once the SEC's proposed rules were put out last year, the market really changed as a result of those rules, and it was almost as if the SEC rules were already in effect. And so with respect to the fairness opinion, the purpose of that is to just ensure that the de-SPAC transaction is fair to the public holders of the SPAC. And that's just within that it's fair in the range of transactions. Now, this is typically something that's more of a state fiduciary law function, but it is in the proposed rules. Now, with respect to the fairness opinion, that's something that the market hasn't fully adopted after the proposed rules comes out. It seems to be more prevalent for Delaware SPACs as a result of some of the case law that's out there in the recent court rulings. The other issue on this is there is a limited number of opinion providers, and some of them are really concerned about the proposed rules' ability to actually consider them to be underwriters, to be deemed to be underwriters under the rule. So there are fewer that are providing opinions that cover both the terms of the transactions and the financing. But to wrap it up, the rules will be coming, and probably sooner rather than later in the next few months.
I had a theory that in terms of bandwidth, you think that all the rules the SEC has on their plate and the stuff that's coming, they're big, meaty rules, and the SPAC rules are as well. And there's a lot of challenge about the scope of those rules. But it feels like the impact that I don't know if the SEC actually wanted the impact. The market has taken a. So my suggestion is that, or not suggestion, my observation is that maybe the priority for the SPAC rules may be not as.
sure.
But yeah, certainly, a year. If this was last year and we were sitting with this proposal, I think everyone would say it's coming tomorrow. But given that the decline in the SPAC markets and the likelihood of many D-SPACs not proceeding, I'm wondering whether, if you're Chair Gensler, if you said I've got enough, I've got these pieces to move on the table, I'm going to choose not to. I'm not going to choose to use those for the SPAC rules. I think they will come. I'm just not sure how quickly. What do you think?
It's interesting though, because typically when you look at the proposed agenda, everything's either April or October, and of course not everything comes in April and October, and they just pick those dates. But they could have picked October, but they still put April, so it still seems like it's higher up on the agenda than maybe we would have thought.
Next question, Scott.
Okay. As you may have noticed, each SEC form has a box in the top right corner that states estimated average burden hours per response, and it puts a number of hours to complete the form. Does anyone use this information to estimate legal fees, and how are these estimates in the forms calculated? So this is admittedly something I never considered before, but the reason for the box is because the Paperwork Reduction Act of 1980 requires the government to actually list the burden in terms of time and effort when they want to get disclosure. And this isn't just SEC disclosure, it's anything, it could be the EPA or whatever. So I can't speak to whether anyone uses those for budgeting. I certainly do not and have not heard of anyone doing so for a few reasons. One, you're rarely creating one of these documents from scratch. Maybe the estimate 645 hours for an S1 is a little more reasonable, given you're probably creating that from scratch. But over time, as you have precedent, a 10K is going to take less time each year. So I don't know how relevant the 2,255.26 hours for a 10K is, and I love the 26. But the other thing is, it's not just legal hours, right? It's all the hours, and it's not just outside counsel hours. So it'd be really hard to parse from that what's outside counsel for budgeting, what's inside counsel, what's accountants, and all that. So, and finally, it's not done in a vacuum. You're rarely paying just for a form. Obviously, with an S1, it's part of a big going public process that costs a lot of money. 10K is part of our normal governance, 8K is stuff like that. So the answer is no, I think.
And just so you know, in every rulemaking, there's a part in the back that's called Paperwork Reduction Act, where they talk about how the staff went about estimating those number of hours. And interestingly, in the adopting release, it'll indicate how many comments they received on their estimates for the number of hours. On the 10b5-1 rule, they didn't get any comments on the number of hours. So maybe that's an area that we can all think about commenting on the number of hours, if only in an effort to get Scott to pay us a little bit more for our work.
That's the section of the release that I never paid attention to until I started working at the SEC and realized this is actually pretty important, but not to practitioners.
To the next question. On March 1st, the CEO of a company enters into a 10b5-1 trading plan in compliance with the new rules. The plan will run for 6 months. The CEO wants the cash to help fund a new home he is building. In May, after 2 months of sales and an open window period, he decides against the house and wants to terminate the plan. Can the CEO terminate the plan? Should you let the CEO terminate the plan? Well, I think there was a problem in the question first. I mean, if it's March 1st means it's a plan under the new rules. I think the CEO's probably, if the CEO's been selling in May, maybe they haven't gone through the 90 days or the cooling off period. So let's adjust the question and say that the CEO was selling securities after the cooling off period. The plan still runs, but made a decision that doesn't need the cash for the plan, the cash from the sales for the purpose, and wants to terminate the plan, wants to hold the stock. Can the CEO terminate the plan, and should you let the CEO terminate the plan? I mean, the CEO can terminate the plan, but the question is whether that's going to have an implication on the sanctity of the 10b5-1 plan the CEO entered into. The release indicates that a termination of a plan could raise questions about whether the plan was entered into good faith, and entered into in good faith, and maybe there's a suggestion that the sales that were made. Or certainly that the CEO may not be able to rely on the benefits of the safe harbor for the sales that were made prior to the termination. Now, should you let the CEO terminate the plan? I don't know. I mean, it's if the CEO entered into the plan at the time on March 1st with all of the requisite requirements, importantly, good faith and sort of no material non-public information, not entering into the plan because he knows something's going to happen later on, and he wants to get sales out of the way, and at some point over the course of that cooling off period, he's not going to be able to enter into a plan. Then I think you have a problem. But I don't know. Not selling isn't a violation of the securities laws, and it would seem hard to go back for anyone to challenge a sale that was made prior to the termination if all of the elements of a good 10b5-1 plan were in place when that person entered into the plan and through the pendency of the plan. He wasn't calling the broker and probing him on advising, adjusting, making adjustments. So none of that was there. Yes, there is risk. Would I let the CEO terminate the plan? I would advise the CEO of all of these considerations, but I think terminating the plan should be okay if all of those elements were in place. But I'd be interested if anyone else has a different view.
No, I mean, that sounds right. And I think it's, to your point, it sounds like the person was acting in good faith through the duration of the plan. So.
Correct. And there's that doesn't want to buy the home or build a home anymore. So there seems like there's a legitimate reason, not for some. So it seems like the facts support that. Let's go to the next question. This is JT.
All right, I think this is going to be a quick answer. So the question is, the compensation actually paid measure that's required by the new rules is not the same as the actual compensation that the subject officer would receive. Is a company at risk that it would be viewed as making false or misleading disclosures under relevant anti-fraud statutes? I think they're thinking about 14A9 specifically, but the short answer is no. This is how the SEC is defining it. This is the way that they're wanting companies to calculate it, and this is the nomenclature that appears both in the rule itself and the tabular disclosure that's required. What I do encourage companies to do, though, is actually make that statement in the footnotes to the disclosure where they say, hey, these are amounts calculated under item 402V, and the actual amounts paid or earned may be different than the amounts reflected here. And where this really becomes more at play is with respect to the equity awards. Under the new rules, unvested awards as of the end of the year have to be valued based on fair value. There's no guarantee that'll be the actual value when they actually vest and such. So I think that's what's driving this question. But that's the short answer way of how I would address this.
Great. Raquel.
The new clawback rule. So the new clawback rule is effective now, but we are waiting for listing standards from the exchanges. The rule, however, amends Forms 10K, 20F, and 40F to add new checkboxes indicating whether A, the financial statements included in the filing reflect a correction of any error to previously issued financial statements, and B, whether any of the errors or restatements that required clawback analysis. A recent CDI said companies do not have to answer the questions reflected in the checkboxes, but do companies still have to add the checkboxes to the covers now anyway? So I'll just pause there and say, my, oh my, this question has gotten lots of play. I've never thought that checkboxes would have so many questions and draw so much controversy. So I've been calling this the great checkbox debate of 2023. Checkbox scandal. But so the SEC did issue CDIs, and then they issued another CDI. So I think it appears to be clear that the new forms, the 2023 forms, require these questions. And companies don't need to actually check the box because the actual listing standard rules are effective. However, I think there's still some open questions, and it seems like the SEC may even put out further guidance on this, because there are questions about, well, whether do these questions have to be on the cover page? And then there are also concerns about whether just actually putting these questions in your filing, actually that's disclosure, and does that create risk for the company because you're not actually checking the box? So we'll see. Hopefully we'll stay tuned and they'll clear some of these issues up. But the 2023 forms do require these questions, but you don't have to answer them.
And the CD&I from last night or yesterday said include the boxes, yes?
I think it said, do you have to mark the checkbox? So, which to me means that you have to put the actual checkbox there.
But interestingly, the answer to the question didn't say specifically you don't have to mark the boxes. It was weird. It could have been. You could have answered it cleanly, like don't check the boxes or check the boxes. I'm just simpleton, so I need that kind of.
So you agree with me? The checkbox debate of 2023.
It's not over.
Right.
It's not
over.
The box. Sorry.
By leaving the box unchecked, you are disclosing that there's no restatement. There's could be a false.
See, there's chapter 2 of the checkbox debate.
Well, I said,
Yeah.
does it create risk?
Yeah.
But the SEC in the CDI says you don't have to check the box. So
We had them all here yesterday. We should have cornered them
I
made them answer the
I
question.
tried to. I
Yeah.
did try to.
Let's move to the next question. This is Scott.
Yep. An NEO at a company decides to resign, and the company will promote an existing officer into the role, but the officer is not currently an NEO. The company will file an Item 502B, Form 8K with respect to the resignation, and 502C for appointment. The new NEO or executive, because not NEO yet, does not enter into an amended or new employment agreement, but the new executive will receive a base salary increase. Does that salary increase need to be disclosed on Form 8K? So there's two paths to disclosure here. One is 502c3, which focuses really on the arrangements or appointments of PEOs, PFOs, PAOs, or POOs, and then compensation related there too. And 502e, which is really about material compensation plans for the PEO, the PFO, or an NEO. So it's really going to come down to what the role of the executive is and materiality of the increase. We know here there's no new agreement, although I'll note that it doesn't have to be in writing. Doesn't have to be an agreement. It can be just an arrangement, even if unwritten. And we know the executive is not currently an NEO, so if they are not also the CEO or CFO, then you're probably safe from 502E, but you'll probably need to disclose under 502c3 unless clearly immaterial in significance. And with respect to that materiality, you're looking obviously towards materiality to the executive, not to the company. A raise is not going to be material to the company. And you just need to consider the size of it and how much, the size of the raise, I think, unless you're really certain it's not material, I think you're probably ended up disclosing this.
What's your rough threshold for material typically? Like, what do you look at? TDC or what are your guidelines?
Yeah, there's what the reasonable investor would like to know. Actually, what we look at, there's no rule on percentages. This is that in that regard, because I can't look at the executive officer's total assets, then I'm going to have to probably err on the side of disclosure unless it's just a tiny nominal raise, particularly at this level. If we're talking potential NEOs.
Yeah, I think most people just tend to disclose it anyway. Yeah.
There was a question that came in just this late morning on paper, and that sort of relates to this part of 8K, and I'll just read it and we'll take it. Form 8K, 502C, the appointment of a new principal officer. Does the instruction to be able to delay until public announcement also apply to internal appointments? So in 502C, there's an instruction that says if you've appointed an officer, you can delay the 8K until you make a public announcement of the officer being appointed. And the question here is there a distinction between an internal or an external appointee? Meaning if you promote someone like here, or if you bring someone from the outside, I don't think there's any distinction. If you're going to delay the public announcement, you should be able to rely on the instruction and delay the 8K.
I agree. Yeah. It doesn't matter where the new person's coming from. It doesn't impact the role.
Okay, another 8K question. I think this is for me. The CEO and CFO are speaking at an important industry conference shortly after the end of the fiscal year. They're going to want to talk about preliminary results for the completed year and guidance for the coming quarterly period and full year. Fourth quarter and full year earnings release and call are weeks away. The remarks at the conference are going to be webcast, and the company issued a press release well in advance to notify everyone of this event and provide the webcast details. Does the company have to issue a press release or a Form 8K in advance of the conference or webcast to disclose the guidance? Okay, so this as like a JP Morgan healthcare conference feel, the thing that happens in the first week of January. And I think this is a common question that for anyone who works at or works with a healthcare company who's attending that conference. Because what happens is when they're speaking, many of them will want to talk about how the quarter went, how the full year went, and potentially what the year is going to look like. Now, everything in the paragraph before the questions, that reads all FD compliant, right? You've given notice of a meeting, you provide all the details, someone could participate. Sounds just like what you do for an earnings call. So do you need to put, now that you're going to talk about some really important stuff, it sounds like you're going to talk about how the quarter went, how the full year went, and what the next year is going to look like? As a technical matter, I don't think you need to put out a press release or an 8K, but is that advisable? I think that gets a little messy, right? You're going to be at a conference, you're going to have a webcast. That sounds like pretty important information. I think a better practice would be to get some kind of information, the guts of what you're going to talk about, and lots of companies do this. Lots of companies, in connection with JP Morgan or other conferences like that, will put out a press release saying, Raquel and Scott are going to be speaking at this conference, and they're going to be talking about the results for the quarter and for the coming year, and they'll put the guts of what they're going to say. And it may just be that guidance information or the expected results. So I think the better practice would be to disclose that in something other than just relying on the webcast. I don't know. Yeah.
We don't present at the healthcare one,
Yeah,
but I
yeah,
agree
yeah.
with you. No, I agree with you.
Yeah, I think you'd want to avoid having to file the release later and so forth. So I think that's a good idea.
Sorry, go ahead.
Just for practical purposes, if you're providing that really kind of important information on a webcast, it's good to also have that in print so you can refer back to it later and say, investors, it's here on page whatever, as opposed to it's that soundbite, 2 minutes and 25 seconds in our webcast.
Second question, if the company wants to file a Form 8K with this information, what item number would it be? When you think about, when you go back and look at this question, you've got full year guidance that you're putting out, you got full year results, quarter results for a completed period. I think that should be, when you think about this fact scenario, you've got a 202 trigger here, right? You've got quarterly results for a completed period. You've got full year results for a completed period. That would trigger a 202. Interestingly, if you look at and companies will remain nameless, but some of the companies that put out an 8K in connection with JP Morgan file it on a 701, and they include completed period results. I'm not sure that's the correct practice, so something to think about whether you should be filing. I mean, it's an FD release, but I think it may trigger the 202 rather than the 701.
And what that means, though, too, if you're under 202, you have to follow all the other requirements, item 2, and then everything else. So it just becomes like any other earnings release, essentially. Yeah.
I think, JT, this is yours.
Oh, more non-GAAP stuff. Okay, so this is actually a question that we got in the last few days. In the accounting panel yesterday, the panelists spoke about the updated non-GAAP financial measures and CDIs. Part of the discussion focused on what would be considered a cash operating expense that would not be considered normal and recurring, and therefore be permitted to be excluded in calculating a non-GAAP performance measure. You provided me with additional examples of cash operating expenses that would not be considered normal and recurring. So I had the pleasure of working with a lot of retail companies, and I'm going to give some examples that I think hit home at what the SEC was trying to get at during this conference, which is the idea of something impacting the business in terms of revenue generation, as well as impacting the business in terms of its operations. So some companies have, during the era of COVID, chosen to exclude salary that was paid to employees while the stores were closed. Now, I want to be clear, these were employees that were normally salaried. They were not wage-earning employees. The SEC said, no, these people would normally get paid. This is part of your ordinary recurring cash expenses. You can't do that. Another expense that I've seen, again, I'm just picking the retail space because I think it's a little bit easier to understand, but it relates to inventory disposal charges. If you're a retail company, you're always going to have inventory disposal charges. You're not going to be able to sell everything else. Again, that's very pertinent to your revenue, your operations as a business. So that's something you cannot exclude. So those are two examples right there. There's a secondary question to this, which is about stock compensation expense from the calculation of non-GAAP financial measures. So we try to do what we can to look at comment letters, and this one has not appeared recently, and I think part of the reason is because this is not a recurring cash expense. That being said, I always encourage this for all companies that do any kind of exclusions to provide the rationale for why this is being excluded. To the extent that you think that this is not material to understanding the operations of your business, which again aligns with what the SEC was saying. In the case of this particular one, if you look at what a lot of companies do, they make it clear that it's not comparable from period to period, subject to fair value changes, and also, to be quite frank, the taxes associated with these sort of charges too also will vary depending on vesting, et cetera. So there's a number of different ways you can try to explain it away, but in any event, that's what I think is general best practice, is provide some context regarding why you're excluding it in the first place.
Raquel, this is yours.
So, new 10b5-1 rules. Under the new rules, companies will now be required under Item 408B2 of Regulation SK to file its insider trading policies and procedures. What does this include? So under the rules, it refers to policies and procedures governing the purchase, sale, and/or other dispositions of the issuer securities by directors, officers, employees, or by the issuer itself that are reasonably designed to promote compliance with insider trading policies or insider trading laws. So I read that and it's very, very broad. So as a result of that, I think it may be advisable for companies to actually have a separate insider trading policy. That is the policy that they file with the 10K in compliance with the new rules. So would this include training materials for employees? I think this is an easy one, and I don't think the SEC would be expecting you to include the employee training materials.
Yeah, I think the approach would be less is more.
Less is more,
yeah,
exactly.
Less is more.
Separate policy would be good.
What about things like pre-clearance procedures and things like that?
I think it depends on whether you want to include that in that separate policy or not. But to me, that seems to go to policies and procedures.
Yeah, I am very inclined to take your view. So.
It's also maybe advisable. This is the time to sort of go and look at
exactly.
what those things look like, right?
This is the time to figure that out.
You just don't want to pull the thing and then scan it and post it on the as an exhibit, right? You should look at it. Maybe it's a time to update it and refresh it and make sure that it make sure that the contact person is either a title or a person that works at the company. That always helps. It's the next one. I think this is USCON.
Yep. Okay. A company is considering a restructuring that would impact employees and qualify as a plan of termination under 205 Form 8K and the related accounting guidance. The plan is reviewed and approved by the company's board of directors in advance, and the company needs some time to notify all the impacted employees. When does the company have to file the Form 8K? Can the company wait until it has notified employees? And if the company can wait, does the company get the 4 days from the notification, or does the company need to file the Form 8K when it commences the employee notification? So, good questions. Normally, the 205 is triggered when the board approves the plan and commits the company is the words they use. But there actually is a CNDI on point. It's 109.02 for those following at home. And it says that the Form 8K can be delayed until it has notified employees. But you don't get 4 more days. So that begs the question of how many days do you get or how long do you get? And there's no guidance on that, and it could take some time to notify all employees. The rule actually says those employees, and that could be interpreted as meaning every single last one of them, but I just don't think that's a reasonable interpretation. Frankly, I'd probably be comfortable giving the company 24 hours or something like that to give them a full day to notify employees, but not weeks that it could take to notify everybody. So, and then one quick aside there is you also have to consider whether that's material non-public information. And so even if you are waiting to notify employees and not filing the 8K, you're sitting on that. You might have to close your window, and it might actually cause you to want to speed up the filing to get rid of that MNPI.
Non-GAAP financial measures. I think this is for me. A company provides GAAP and non-GAAP EPS for 2022, and it provides guidance for full year 2023 non-GAAP EPS. The company cannot calculate projected GAAP EPS with accuracy because of the uncertainty associated with the adjustment. Does the company have to provide the reconciliation? I think there is a within 10E you're permitted to take the exception not to provide the reconciliation if you identify that it would be unreasonable or take unreasonable efforts to calculate or to prepare the reconciliation. you have to explain what that information that's not available to calculate the reconciliation, and you have to identify what the probable significance is. So you'll see some companies who provide a sort of projected non-GAAP measure. Some companies are able to provide the reconciliation because the adjustments associated with it are ascertainable. For those that can't, you'd have to identify, and you'll see oftentimes in a footnote, a description of that we're not providing the reconciliation, can't calculate the gap number, and the nature of the adjustments that they might not be. Maybe it's some litigation or there's some adjustment that they're making to the calculation of the measure that they're unable to. So otherwise, that's why they can't get to the gap measure, and that sort of makes sense, right? If the company's sort of driving their business towards the performance, they're often driving towards the non-GAAP measure rather than the GAAP measure, and being able to project your non-GAAP measure seems plausible. Some people always ask, if you can get to the non-GAAP measure, how can you not get to the GAAP measure? But if you think about how the executive team is running the business, I think you can understand how they're not necessarily considering all of the gap adjustments that they might have to reconcile out to get to that number. So the second question: what does the new non-GAAP guidance say about equal prominence when presenting a non-GAAP measure without any corresponding GAAP measure? So I don't know if you remember yesterday, Lindsay McCord, the chief accountant of CorpFin, talked about the new guidance that came out in December, or it was adjustments or enhancements to the non-GAAP CD and Is. And there was one that sort of focuses on equal prominence as it relates to sort of projected or outlook non-GAAP EPS. And interestingly, it indicates that the words clearly say it would be considered more prominent if the discussion about why you're unable to calculate the GAAP measure and provide the reconciliation, if that's not given equal prominence. And I'm not exactly sure what that means, because lots of companies will have, they'll have their headline for their press release, and they'll have a series of bullets underneath that, and one of those bullets will often be the EPS outlook, and it'll often be a non-GAAP EPS outlook. Now, I'm not sure if that CD&I says that you have to put all of that stuff about it being unreasonable efforts and the probable significance within the same bullet, because I know the companies I work with would go nuts if they had to put all of that stuff in that bullet. So I'm not sure exactly where the staff will come out on this, but sort of the advice that I've been giving is sort of, you've got to address it somehow. Probably at the back probably doesn't satisfy equal prominence. Maybe you can try a footnote on that for the bullet. Maybe under the bullets you can have text that follows under the bullets that indicates this information. But I'm not exactly sure it's necessarily practical to sort of work through that guidance if you have to put it embedded within the text. And that's 102.10. So 102.10 is that new guidance. JT.
All right, so this is a good question, and this one relates to pay versus performance. And it was such a good question, we actually submitted it to the SEC. So what I'm going to tell you now, I want a caveat, it could be completely wrong. So, all right, the question is, in calculating the equity award adjustments under new pay versus performance rules, are equity awards granted to a first-time NEO in a year prior to and not otherwise related to their appointment as an NEO considered? For example, if a non-NEO employee is granted a stock option in year 1 and subsequently appointed as PO in year 2, must that PO's compensation actually paid figure reflect the adjustments required under the pay versus performance rules, or would such award be disregarded? So if you were to look at the plain language of the text and how you're supposed to calculate compensation actually paid, they refer to any awards granted in any prior fiscal year, quote unquote. So that clearly would pick up awards that were awarded in a prior year when that person was not an NEO. That being said, this is very asymmetrical to how you deal with other summary compensation table information, in which case, you see Scott's nodding. The reason why is if in prior years where the person's not an NEO, you wouldn't report any compensation for those lines. And if you look at this table, one of the columns says total summary compensation paid in this particular fiscal year. And then you have compensation actually paid, which includes compensation prior to that NEO. There seems to be an asymmetry there. I'm not quite sure if the SEC thought this through. This is a question that I actually got before this conference. So again, hopefully there'll be a different answer. But right now, the plain language says any awards granted any prior fiscal year. What I would recommend practically, though, is in your narrative disclosure where you're trying to show the relationships to mention that fact and try to provide context there as necessary.
Raquel.
New 10b5-1 rules, so popular topic. So do you expect the narrative disclosure that will be required under new item 402X of Regulation SK regarding a company's policies and practices related to the grant of equity awards close in time to the release of material non-public information to be any different than what is already included in CD&A? And before answering this question, I have to give a shout out to my colleague Shalom Huber, who helped me with this answer and reminding me of something really important. So this new item 402X isn't really that much different than what disclosures about equity grant practices that most companies included in their CD&A back in 2006 and 2007 when the option backdating scandal was really fresh. So the SEC provided a lot of comments on that issue at the time, and most companies then started putting in disclosure that was very specific and described as equity award grant practices. But that sort of fell off a little bit, and now companies don't include that level of disclosure as much as they did back then. So we see now with the new rule a real resurgence of the SEC being interested in the timing of awards, of option grant practices. So companies will need to be prepared to either to start including a lot more detailed discussions in the proxy statements about their option grant practices. So similar to what we saw back in 2006 and 2007. So if I was talking to you in 2006, I would say, no, the CD&A is going to look about the same, but it's probably going to look quite a bit different now for most companies.
Would you recommend companies adopt like an option grant policy saying that they can't make grants during the periods that the SEC says disclosures are required, or what's your view on that?
It's a good question. That's one that comes up a lot. I would say not necessarily. One of my kind of premises is a company has to run its business. You can't run your business just based on changes in SEC rules all the time. So several companies have specific policies where they grant options, say, at a specific date every month. And so I wouldn't say that you necessarily need to change that just based on the SEC rule that's going to require more disclosure. I would say just put in the disclosure as opposed to thinking about changing the policies that you've had in place for years that have been working well.
Yeah, I think it almost looks more questionable if you start trying to change your policies around dates. You're considering MNPI, you're considering the AKs, and then you're trying to move your dates around. It's a machine at Salesforce to grant all the equity, and we're not going to change it for upcoming events. And not that we couldn't, because we might not know certain events that are going to happen until right before they happen, and at that point it's too late to stop the machine. So we are going to just kind of rely on how we do things. We've done it for a long time, and if that requires new CD&A disclosure, so be it.
And see, it's not really new CD&A disclosure. It's the disclosure that was already supposed to be there.
The new old disclosure.
The new old disclosure.
Scott.
Another 8K question. Which share number should be used in the denominator when calculating whether an unregistered offering constitutes over 1% of shares outstanding? Under item 302B of Form 8K, is the number of shares outstanding to be used as the date of the offering or as the date of the last periodic report? And if the number of shares outstanding is the number as of the date of the last periodic report, should other prior unregistered offerings since that date be added back in when evaluating a new unregistered issuance? It's a mouthful. Item 302B of Form 8K does require a disclosure of unregistered offerings unless all of the aggregate offerings since your last either 302B 8K or your last periodic report are less than 1%. And so this disclosure requirement is triggered when you enter into the agreement, not when you issue the shares, by the way, but it's set on the date that you use when calculating the shares. Here, internally, the company will have a real-time count of shares outstanding, but you actually use the number as of the last periodic report or the last 302 8K. And the reason for that is simple. I mean, the goal is that you're trying to not just do one offering, but all of the offerings in between. So you could have a lot of small ones, you need to add them up. And if you just took a real-time count on the day of the new offering, that would, all of those other issuances would already be included in the denominator and they would wash out, and that's not the intent of the rule. So actually the only time you would use the real-time count is if you just went public and you didn't have an item 302, 8K, or a prior periodic report, and then you can use your real-time count.
That's a great question, Scott. I'm glad that was one of, not to reveal the source, but Scott was the source of that question. Glossy annual reports. The new amendments to 14A3C require companies to submit glossy annual reports on EDGAR. What does that mean? Does it matter whether it is glossy or not? Does that apply to a wrap of the Form 10K or just a standalone book? When does the glossy annual report have to be submitted and is considered filed or furnished? So in June, the SEC adopted amendments to Rule 101 of Regulation ST, which mandates the electronic filing of certain documents on EDGAR. It includes annual reports. This is not the 10K annual report. This is the glossy annual report, or glossy annual reports that aren't glossy. So it covers both. So what does that mean? I mean, what that means is that that book that companies might prepare that sort of accompanies the proxy statement or that comes along with the annual meeting, you need to put it on EDGAR. And the question here, does it apply to a wrap or a standalone book? Some companies have a multi-page document that they stuff their 10K inside of, and I think it applies to both. If some companies reproduce parts of the 10K into that glossy or unglossy book, other companies just have the glossy book. I think in whatever thing you're sending, I think the idea here is that that these I think under the rules constitute soliciting materials, and you have to sort of comply with 14A3. In 2016, the staff said you could post these things on the website on your website, and if you kept it up for a year, that would sort of satisfy your obligation to provide copies. And now what we're being asked to do is file it on EDGAR, and it files in a PDF. It's not filed; it's just furnished, unless you reference it or incorporate it by reference in some specific manner. You can't reformat it or redesign it or change it in any way. So I'm not sure what implication that'll have on companies. I'm not sure whether the formats of these documents, I presume they can get converted easily into a PDF format that can get furnished on EDGAR, but that's something lots of you are thinking about. But as you prepare your wrap or your glossy annual report, make sure you get it filed on EDGAR. JT.
New clawback rules. In light of the new compensation clawback rules, should a company amend its clawback policies to address recovery for any purposes beyond the new requirements or what the stock exchanges will ultimately require as a listing standard? So I think I know what's driving this question. This question is being driven by the fact that institutional investors want to see more than just clawbacks in the event of restatements. They also want to see clawbacks in the event of misconduct. We talked a lot in this conference about the McDonald's case, for example. There actually was a clawback in that case that was negotiated with the CEO, former CEO. And this is also kind of evident in the fact that the DOJ has recently focused on this issue. Assistant Deputy Attorney Monaco, I believe last fall, actually issued a memo to prosecutors in terms of setting guidelines for determining penalties. And one of the things that they consider is whether or not a company actually has a clawback policy in place. And such clawback policies would, again, cover misconduct as well. And part two to that, the companies are actually enforcing their policies. So I think there's something really important to keep in mind, which is that's all great, and maybe that's something to consider. I think you also need to think about in terms of implementation. The SEC has taken the view in the adopting release that you can rely on federal preemption for anything that you claw back under the required rules. That would not pick up clawbacks in the event of misconduct. It would only pick up clawbacks that are actually mandated by this rule. In which case, I think you need to be really careful if you're going to add this language. You should definitely put in stuff that it's in your discretion, et cetera, because there are also state employment laws at play that can really prohibit you from being able to claw back amounts that are earned. If you're going to do this, again, I think you need some of that hedging language in the policy itself, and in your documentation regarding your plan documents, your equity agreements, your bonus incentive plans. You should also have language to that effect. I'm not an employment lawyer. This is what folks like that say. The other thing I would say too is if you're going to have this in there, Part B to the Monaco recommendations was that the companies actually have to be enforcing against this and doing this, and so you should be prepared to actually at least have those sorts of conversations within that. Yes, this is not just for show, but you're actually willing and able to do these things.
And as a practical matter, implementing that as in-house counsel, you're not going to be a popular guy, right? Oh, wait, the law requires this, but we want to go farther, and they're not going to love that. So I'm not sure who would drive this internally and where this would come from, where the motivation to do this would come from. But we'll see what the enforcement actions are and see what happens. But I don't want to be the face of that.
No.
Okay.
Raquel.
I think this is an easier one. In what year do we have to include a copy of the company's insider trading policies as an exhibit to a Form 10-K? Could it possibly be the one filed in 2025? And the quick answer to that is that's correct. It's 2025. So yesterday, the director of CorpFin confirmed this in the session, and he said for calendar year-end filings, the exhibit will be required in the annual report that covers the fiscal year beginning January 1st, 2024. So that'll be the filing in 2020, like the 2025 10K.
Not to create a new controversy after the checkbox one, but I heard it differently yesterday, and so I'm going to wait. I'm going to wait for the. I'm still. I mean, it'd be great if it was 2025, but I'm going to wait for. Eric promised that they would.
He said they may put out more guidance, right?
More yeah, he can't really. I mean, that feels like it's, I don't know, not FD compliant for him to say it here and for all of us to rely on it. Okay, we're running out of time, so let's move on. This is a good question, Scott.
Is the health condition of your CEO considered material information? I'll forget. I won't read the rest of that. It's interesting. These are two good but distinct questions here. And after COVID, this actually isn't just a hypothetical. Altria Group, for example, did file an 8K announcing that its chairman and CEO did contract COVID and had to take a leave of absence. But generally, market practice is that you don't disclose illnesses. 8K 502B really only touches on retirement, resignation, or termination. It doesn't touch on illness. But you still have to ask yourself, who's doing the job and who really is performing the functions. And if that's the CEO from the hospital bed, then probably no 8K. But if the board has designated the duties or an interim CEO has stepped up, then you will have triggers both for the stepping down of the old CEO, the step up of the new CEO, and there's a CD9 point actually related to CFOs about an interim CFO stepping down, and you have to do 2 8Ks when that happens, and then when the CFO comes back, you got to do 2 more 8Ks with the reverse. So there are 8K triggers that are based on who's doing the function. Now, is the health MNPI? Again, back to your reasonable investor standard, but I think you just really think about how serious the injury is. Is it his appendix? Is it her appendix? Maybe not. Maybe it's not MNPI, but is it late-stage cancer? It might be. And so you got to think about how serious it is and how sudden it would be. So I think it could be MNPI for sure.
We are running short on time, so I'm going to jump to. This was a good question. JT, this is, I think, yours.
Oh, man. I thought I was going to run out of time.
No, we can.
I can answer. I can answer for sure.
We can go back to the
given the recent SEC enforcement proceeding against McDonald's related disclosures made in connection to termination of its former CEO, what should companies be disclosing when an executive officer is terminated? This is a great question. I'm not going to repeat the facts of the case. We're running out of time now. But I think the most important thing that came out of that was in that case, the Compensation Committee had to use its discretion to apply the without cause termination benefits. It was not provided for under the plans because they did say that he violated the code of conduct. I think any company that does this, and this is a really sensitive issue for companies, just terminations generally. I spent most of last year dealing with a lot of these issues, and the proxy advisors want to see a termination that is involuntary. They don't want to hear departure, this and that. They want more information. And they certainly would want to know if a termination was without cause was one that was at discretion versus pursuant to the plans. At the same time, that's not necessarily information the companies want to disclose for various reasons. However, in light of this case, if that's the case, I definitely think you should disclose that the decision was based on discretion. And moreover, if you look at that opinion, you will also see that there is a reference to the factors that the committee considered in making that decision, which is explicit language that comes out of 402B. So I think you do need to provide a little more color as to what factors led them to still conclude that. I think you need to be very careful here. I want to caveat that. There's a lot of confidentiality agreements that are executed in these things, so you have to be probably bring in your employment folks. I'm always a big believer in cross-functional. I've used that word before. But long and short of it is I don't think you can simply just say termination without cause when it's clearly in violation of the plans themselves, like the terms, as far as that right actually being granted. So you have to definitely provide context in light of that.
So the important thing to remember is when there's a termination, as you're thinking about the termination, also think about the disclosure that you might have to make, because you should be able to address that as part of the termination arrangements, to know that you're going to have to likely present some information in your disclosure, and people should be aware of that as they're negotiating.
And be prepared too. A lot of times, I think this was mentioned earlier, this terminated executive is going to have to review that disclosure. So there's going to be a lot of back and forth, and it's going to be stressful. But at the end of the day, you just have to keep decisions like the McDonald's one in mind.
Sorry, go ahead.
No, please.
I was just going to say, as a result of this, I think we're going to see a range of disclosures, and I don't think companies are all going to be doing it the same way. I think it's going to play out for a while.
I didn't think we had enough questions, but we didn't have enough time. But the questions are here, so we can debate them on the beach or on the airplane or wherever you'd like. But we're out of time. It was wonderful to be here. I want to thank all of our panelists and all of you for the questions you gave us, so that we could share this with you today.